Bryan Kohberger's case has a new day in court, but is it something that's really going to stick? We've watched some changes in the Bryan Kohberger case since the case was moved to Boise, Idaho. Hi, I'm attorney Andrew Myers, and joining me in this episode is attorney Yolie Medina. Hey, Yolie.
Hi, how are you?
I'm good. I just want to let people know that Laney is off for a few days, and so Yolie was nice enough to join us. And Yolie, I don't know about you, but everybody's saying that it's a new day. I've said it. It's a new day for the Kohberger case. Do you agree with that?
Meaning a new day, meaning there's a new judge, there's a new ambiance, there's a new vibe. Is that what you mean by a new day?
I guess so. Sure. I guess I was too general. We attorneys like to be more general. I mean, more specific. And you're right to call me out on that one. But it just seems like the tone has changed. It seemed like when the case was being handled by the court up in Moscow, Idaho, it was kind of a more laid back, we'll listen, we'll take it under advisement and see what happens. Now, this judge, Judge Hippler in Boise, is being pretty stern. He's setting deadlines, expecting people to keep them, and kind of admonishing the parties too.
Yeah, this is kind of, Judge Hippler is the kind of judge I'm sort of used to. And as you know, with Judge John,
yeah, it's a mouthful, isn't it?
It's JJJ. Well, he was very laid back. I mean, there's still rulings that I don't think were ever orders that I don't think were ever complied with. Some of them might still be outstanding. Now, I don't know what happened to his alibi defense and where that went or what the status is on that.
Well, I've only heard rumors about that, and so I like to stick to what we can actually report to people. Why don't we take a look at one of the pending matters, and that is the motion for a Franks hearing. The judge wasn't really thrilled about the way the motion had been presented. Here's the judge's order on the Franks motion, and it says, before the court is defendant's motion for Franks hearing, November 14th, 2024, and memorandum in support of motion for Franks hearing, November 18th, 2024. Accompanying the motion are 38 exhibits comprising over 2,000 pages. Unfortunately, defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits, instead referring simply to the exhibit number without identifying the precise pages at issue. So you know me, Yolie. I always say the important
footnote.
Yeah, well, you know me. The important stuff is always in the footnotes. And in my opinion, this is the meat of the order right here. By way of example, defendant cites generally to Exhibit D9 for the proposition that law enforcement's vehicle expert felt more comfortable setting the date range of 2011 to 2013 for the Elantra. That exhibit is over 100 pages of duplicative emails. Defendant does not identify which email supports his proposition. The court will not do counsel's job and scour the exhibit to decide what portions defendant must be suggesting supports his assertion. I don't know. What do you think about that language?
Well, I kind of agree. Especially in a motion like this, you really have to pinpoint what you're talking about. Because if it looks like it's just repeat emails, they might be chains of emails. You get chains, and when you print them out, they come out like repeats.
Yeah, I hate to be critical. I hate to be critical of Ann Taylor because she's an experienced attorney.
Right.
I know a lot of people out there don't like her, but a lot of people like her, and I know she's an experienced attorney. But in my experience, writing memoranda, when you're making a point and referring to something in an exhibit, and we've never talked about this before, but don't you cite a page and line number in a memoranda?
Yeah, page and line, or if it's like an email, you cite the page of the email that you're talking about, so that it's not you're not digging, the judge isn't digging through information. So
right. So we've never talked about this before. We just kind of went on this afternoon, and I said, why don't we talk about this? But yeah, like you say, if it's not a page and line reference, which is what a judge wants, somehow you refer to, if it's a photograph, you say Exhibit D, Photo 1, and you see the thing in the upper right-hand corner. And I've even taken photographs and circled what I wanted them to see.
yeah,
I've
so
submitted.
highlight.
Exactly. It can be Exhibit A and A1. A is the whole photograph, so they see you're not doing anything funny. Then A1 is where you circle it and highlight it and do whatever you want. But so
Right.
to play devil's advocate, all right, to play devil's advocate, why can't the judge, it's the state capitol, it's a big court, why can't he just have his paralegal or court clerks go through it?
Well, he's trying to make a point, I guess.
Yeah.
He's trying to set the tone that, you need to, because otherwise he could be guessing as to what he's talking about. She does describe it in terms of they felt more comfortable with the 2011, 2013 Elantra, but I don't know what the email exactly says. So he may not know, he may be speculating if he picks which email is the one.
So let's go back to the court's order. We left off at footnote 1. Thus, the court is left with the unenviable task of sifting through pages and pages of largely irrelevant documents to ascertain what portion defendant may be referring to. The quote, court is not required to search the record looking for evidence. Okay, that's an Idaho case. Consequently, if defendant wants the motion to be considered, he must file a revised memorandum identifying the relevant portions of the record by page number and line number if referring to testimony. That's what we were just talking about for the facts asserted. In addition, defendant must resubmit his supporting exhibits to exclude portions that are not relevant to the motion. Because the state is under a deadline to respond, the court will allow the defendant until Tuesday, November 26th to submit the revised filings. And I know there were some filings, but it was all sealed. So yes, I'm aware that there were filings, but they were all sealed. So I don't know. That's not the first time, that the judge has been a little bit terse, I'll say, with intel.
I think, to take out irrelevant exhibits, it may be that the whole exhibit is relevant, but just in context, you know what I mean? Maybe it provides context. But he's harsh. He's very hard, meaning like you have to stick to what he wants, and it's a learning curve because, as we all know, the prior judge, JJJ, I'll call him.
John Judge.
Yeah, he was more lenient, and I think part of the reason was the workload, that he kind of had a hard time keeping track of things. But this judge seems to be wanting to set the tone and have it strict, and he might be overly strict, but I would prefer that rather than too lax, because too lax, one of the parties is going to take advantage of the lackadaisical,
And now, as we know, Judge John Judge, JJJ, as you refer to him, he's going to retire.
Oh.
He put in his retirement papers.
But I guess, he must watch himself, and maybe he thinks that, maybe he thinks he did a bad job or whatever.
I think he knew. I think he knew he was in the hot seat. I think he knew that no matter what happens not no matter what, but if Mr. Kohberger is convicted, there'll be years of appeals. There'll be, at one point, Jay Logston said this case could go on for 28 years.
I know.
And no judge wants to be overturned. That's not a good day. None of us like to be told we're wrong. None of us like to be told we made a mistake. But a trial that's going to last 3 months to and it's one of the grounds for appeal that the court erred, it abused its discretion, or whatever the case may be. And who wants that? So if he's ripe for retirement, I don't know. So I was reading a bunch of stuff, and I came across this article in Newsweek of all places, and I just thought it was interesting. It put everything in perspective, and it points out that, yeah, everything will be appealed, or can be appealed. I mean, it's pretty obvious to attorneys like you and I, but I just thought this was an interesting article. Again, it's from Newsweek. Bryan Kohberger's death penalty defense may shape Supreme Court appeal. And I bring this up only because I think the DP might be only one thing that could be appealed.
Yeah, that the death penalty, yes.
Yeah. Bryan Kohberger's lawyers lost the battle to keep the death penalty off the table in the trial, but their arguments could be used for an appeal to the Supreme Court. This is background that we all know, but it does bear repeating. Kohberger, 29, was charged with 4 counts of first-degree M and 1 count of felony burglary. He is accused of fatally stabbing University of Idaho students Madison Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin in an off-campus house in 2022. His attorneys tried to get the death penalty taken off the table, but Judge Stephen Hippler will allow a jury to consider it if he's convicted. David Leroy, former Attorney General and Lieutenant Governor of Idaho, told Newsweek that Kohberger's attorneys' arguments might be more compelling at the appellate level. I've said that all along. Doesn't that make sense?
It has to be. I mean, I couldn't sit through the whole hearings, through all of them. I just couldn't. But the arguments were more for appeal. They were not something that Judge Hippler could actually decide.
No, I agreed. Yeah. I mean, it's appellate level stuff. I mean, you go to a trial court, which you go to all the time in California. I go to here in the East Coast. You can't tell the district court, the trial court, to change law. That's just not their job. And that's what they were looking for, really.
Yes, that's what they were looking for. And so for people who are not attorneys, they kind of felt like the argument was like premature, or, why are they arguing this now? And I think the judge set those deadlines for these motions to be heard at this time, because they also, there was a lot of questions about whether or not these arguments were premature. And since, I don't know if they're premature, but I know that they were set by the judge. These are the deadlines for the death penalty motions. So they have to comply with those. And I also think the defense got a little overwhelmed and had to put things together at the last minute. And maybe that's why the other motion, the Franks motion, wasn't, they didn't cite specifically which exhibit number had. What's this?
Yeah, I guess. Yeah. But on the other hand, they did file, what was it, 13 motions at the same time on the DP.
Yeah. And
so if they're capable of doing that, and then there are a ton of motions to suppress filed at the same time. So they're capable. Ann Taylor's team is to file a volume of material. We don't say a pile of paper anymore, just a volume of electronic material. So maybe you're right. Maybe the Franks motion, which we knew was coming, was just like, oh, wait, we got to do this too. Hurry up. So I don't know. It
could have been. Who knows? But in any event, he gave them a chance to resubmit it, and they resubmitted it, and we'll see what happens. Do you think the court will grant the Franks motion to have a hearing?
I don't have a crystal ball, but I'm going to say the way this court is going, I doubt it. I think they're going to let in as much evidence as they possibly can, unless, a Franks motion is based on the allegation that law enforcement did something wrong. There was a misstatement. There was an untruth. There was a bald-faced lie. They made something up in the affidavits in order to get the warrants. So barring some evidence like that, and we don't know, I've actually put in a request to get some information out of the court, and I haven't heard back from them yet. But I don't know. What do you think?
Was it sealed stuff that you requested? Sealed documents?
Yeah. Remember back in October, the court put out a message that if anybody would like to have if anybody would like stuff that's sealed, now I'm tongue-tied. If anybody would like to have some of the material that's been sealed, unsealed, here's a procedure. Here's the form. I filled it out. Here's how you submit it. I submitted it, but I haven't heard back. So
interesting, because some people heard back and said, like, no, we're not giving it to you.
Well, my point is, why did they initiate the procedure if they're going to say no?
Well, I think it's because the judge wants to revisit that. Every request that comes, he's going to see, should this be sealed,
Yeah.
I think that's what it is, but that's just my opinion.
I'm waiting. I put it in, if I remember correctly, and I will revisit this in the next episode, but I remember that I put it in on October 15th. So we're, 6 weeks after that at this point. We're going into December now.
Wow.
So anyhow, I submitted my request and I'm not holding my breath.
Well, going back to the Frank's motion, sorry, before we get to this, even if he denies the Frank's motion, he denies the hearing for the Frank's motion, that doesn't mean that Ann Taylor can't cross-examine these officers and
of course
point out their inconsistencies and why they wrote what they wrote and the timeline and cross-examine him on all of those issues. So she'll still get to do that, even though so it might look bad. It might still look bad if Ann Taylor cross-examines them and they don't have their story straight.
And if we go back to the hearings that were back in May of 2024, the officer Brett Payne and the other officer just really didn't look like they were sharply on top of it all, in my memory. So if they look like that, I don't know if the Frank's motion will be successful. I don't know if the motion to suppress will be successful. But if they're that way on the stand, in my opinion, law enforcement's in trouble in this case.
Yes, I agree.
We go back to the Newsweek article. The motions that were made were far-ranging and generally designed to be available to the defense to create federal court and United States Supreme Court arguments someday down the road, should the defendant be convicted, and the jury also find him subject to the DP. Leroy said, that's the former Attorney General of Idaho. The Supreme Court has interfered in DP cases on several occasions and I found this interesting, since the death of Justice Ruth Bader Ginsburg and her replacement with Amy Coney Barrett in 2020, the court has stopped 2 executions and reversed a lower court to permit an execution 9 times. So I thought that was interesting.
Wow.
There are the pictures from the Newsweek article. Leroy said, while Kohberger's defense attorneys always took a broad approach addressing various humanitarian and sociological issues surrounding capital punishment, the facts surrounding this trial are not very sympathetic to supporting an argument of essential unfairness. The defense filed 12 motions objecting to the death penalty, all of which Hippler denied in a 55-page order. The motions raised various arguments, including the state's criteria for the death penalty, changing public opinion, and international law. The motions are part of the defense strategy to vigorously contest the government's case, and in so doing, reduce the chance the death penalty will be successfully obtained during any sentencing. Michael McAuliffe, a former federal prosecutor and an elected state attorney, told Newsweek. So the thing I found interesting about that article is, we all knew that, an appeal is likely down the line depending on what happened. But, it just reminds people that, and I don't think capital punishment is the only issue that could be appealed down the law. We haven't even gotten to the trial yet. And there's, as you know, there's always appellate issues in a trial.
It could be from jury instructions to evidence, allowing evidence into the case, and they can appeal, the judge's decisions throughout the trial if they believe it materially affected the outcome. It's reversible error, right? So
absolutely. Now, judges are given wide discretion on evidentiary rulings and other matters, but I mean, jury instructions have to pattern the law. They really do. And Idaho, like Massachusetts and New Hampshire, where I practice, Idaho law has stock jury instructions. You can actually look them up online. And a long time ago, we actually put some of the jury instructions up on the screen, like we just did the Newsweek article. But as you know, no two trials are alike. And so jury instructions are not widgets that can be replaced one to the next trial. So there's always, as you know, there's always a jury instruction hearing where the parties, say, well, these are the standard jury instructions, but here's what we want. And the other side says no. So yeah, you're right. That could
They
be
tweak them. Yeah.
Yeah.
They can tweak them, or they can craft a jury instruction based on a case.
Plus the standard jury instructions, which again are online, you can research them and pull them up. They were written based on the case law at that time, and they were written by a committee of attorneys and judges that sit down in a committee and put them all together. Well, there may have been newer cases since then that the jury instructions weren't patterned. There might be some different. This is a major case. This is a big case, and so they're not going to just pull stuff out of the form book, or I'm dating myself, pull it down off of line. And just have, so anyhow, yeah, there's all kinds of stuff that could happen.
Yeah, there is. And I'm just fascinated by this case. I just don't know what's going to happen. I mean, you're literally sitting, waiting on pins and needles to see whether this Frank's hearing is going to take place. And even if the hearing takes place, that doesn't mean he's going to grant it.
No.
So there's many levels, So first it needs a hearing. It needs to be granted a hearing, and then after the hearing, we'll see if he grants it. So there's 2 steps involved.
And that's one very important, but one motion. Then there are the dozen motions to suppress. And I always found those fascinating. I've always found those fascinating, the motions to suppress. As one commenter said, if all of the motions to suppress are granted, there will be no need for a trial because there won't be any evidence. That's not happening.
No, it's not. But the one thing that I do question is the way he was arrested in Pennsylvania. There's a motion to suppress that arrest warrant, and I find that interesting because Jay Logston argued he wants a judge to consider a conflict of law issue, which law applies, because number one, they arrested him as a fugitive under the fugitive statute, which I personally, in my opinion, don't believe he was a fugitive.
No, I saw that you very recently, before we're doing this episode together, I saw that you did a whole episode on that. Yeah. So maybe I'll put that down in the details section.
Yeah, I've done 2. The first one was just about the paperwork and how he was arrested as a fugitive. And then the other one was based on the law cited by Jay Logston, that you either need a governor's warrant for a fugitive arrest, or you need to have probable cause in that state for an arrest.
You mean, wait a minute. So they never went to the governor. I know that, right?
No.
They never. But are you telling me they need probable cause in Pennsylvania? Well, what did he do in Pennsylvania besides run and throw his trash out with gloves on?
That's the question.
Really?
And so Jay Logston is arguing that part of that Pennsylvania has no jurisdiction to use an arrest warrant in Idaho. In other words, they have to have probable cause that either he's a fugitive, meaning he fled justice,
right, which he didn't.
He didn't. Charges weren't pending. Or they have to have their own probable cause affidavit, and it's a conflict of law because each one has different elements, I guess.
So I think I remember from watching your episode, and I think I was eating lunch at the time, but I apologize. I think what you were saying, and from just briefly looking at the paperwork, there's Idaho law, there's Pennsylvania law, but there's also federal law. Now, how would federal law apply? I remember studying conflict of law for about a year in law school, but it was that long ago.
I did too, but I don't remember. I think the judge has to decide that, and I don't know if federal law comes into the picture.
I don't either.
I don't know. And I'm actually paraphrasing because there's differences in Pennsylvania and Idaho law, but they're the same on one element, and I can't remember what that element is, but it's going to be interesting to see how Judge Hippler decides, because if he was really a fugitive, they would have had to obtain a governor's warrant, or the governor's office needed to sign off on it or something like that.
Yeah, and he, as you pointed out, I mean, I guess you have to be a lawyer to break it all down. I don't know, but to be a fugitive, you have to violate something. Either there's a warrant out for your arrest, or you are out on bail or probation. Yeah. There's some kind of a legal proceeding against you that you're violating, and that's not the case here. This occurred after Mr. Kohberger and his father took the Hyundai across the country, and there were investigations. People were talking about, but nothing had been filed at that time. So
the charges were filed after he was already in Pennsylvania.
So that's an odd little thing. I can't see them dismissing the whole case for that. But then again, I mean,
well, what I think that would happen is probably the materials that they obtained from there could be possibly suppressed, but because they have one for the arrest warrant and one for motion to suppress the items recovered from there, from the home. And one of the things that I want to try to educate people on is that motions to suppress are different from motions in limine. Motions in limine, for example, let's say there was a gun that was found at Kohberger's house, which there was, according to the search warrant return, they found a gun. And a motion in limine, even if that's allowed to, is not suppressed, but a motion in limine can keep that out, because how is that relevant if there was no gun during the crime? There's no allegations that he shot people. It's just prejudicial. It's too prejudicial. It makes him look like a bad guy when, in fact, the gun is likely irrelevant because there was nothing to do with a gun. I mean, there was no gun allegations.
That's always been a point that I wasn't totally clear on, and I thank you for clarifying that. The difference between a motion to suppress and a motion in limine, I think from what you just said, a motion to suppress is based on the fact that it was illegally obtained and
violation,
right. Whereas a motion in limine is based on relevance. Okay, they got it legitimately, but it's not relevant. I think that's
prejudicial, and prejudicial because it makes him look like a bad guy.
Right.
So, and they found a green leafy substance in his house.
Gee, I wonder what that was. Maybe he was making pizza with some oregano.
Probably.
But one of the things that stood out to me, and maybe it's a clarification in my mind, and that was that the FBI and the Pennsylvania State Police were doing two different simultaneous investigations. Yet another example, folks, of government agencies not talking to each other. But I think it was the FBI that while Bryan was home, he was going out and running. He was going out and he was going to the drugstore, for whatever you needed at the drugstore. Maybe you needed toothpaste, who knows? But I mean, you in a previous episode pointed out that, the Long Island serial killer was nabbed in the middle of the day, in the middle of Manhattan on a business day without incident. And so in my mind, I'm thinking, why did they have to go into the parents' house with the flashbangs and break all the windows and break all the doors when, and I got a commenter that really excoriated me for saying this, but I mean, why? Yeah. You don't know. He could have had this and that and the other, but it made no sense to me that if he's out running, I mean, when you're running, what do you have with you?
I mean, it just seems so strange that they would have done it. And apparently, according to the paperwork, and I haven't looked at all of it, but there are some people citing to paperwork, and I don't know how accurate it is, but they held the family at gunpoint at a certain point. That's odd. It was a no-knock warrant. And so now I remember it was a no-knock warrant. And those are special warrants under special circumstances where there's exigent circumstances or other circumstances, which, I don't practice criminal law, but there's other circumstances where you use a no-knock warrant. And I I don't think there was those elements that were met in this case.
I agree 100%. Now, I just mentioned our wonderful commenters. So let's take a look at a couple of the comments that we've gotten in this case. Mr. Haru tells me, people always say they want defendants to scream their innocence from the mountaintops, but when you do, that's also frowned upon. So.
Well, I think the smart thing to do is just stay quiet. And one of the things about Bryan Kohberger is he hasn't said a word.
Yeah, no, he hasn't. No, and people are being, I don't want to cross into the other case we're following closely, the Karen Reed case, but people are extremely critical of her, having done interviews with ABC, NBC, Vanity Fair, and Boston Magazine. So anyhow.
This is from something Lavender. I can't read the name.
Yeah, me neither. Whoever did this slide is going to be fired.
Okay. It says, I came up with a great question about DM and the Idaho house. Wasn't there a small step by DM's room? It was like 2 or so inches high. She said the perp was 5'10". Was he 5'10" on the step or 5'10" after the step? If the perp was 5'10" before stepping down, that would him actually shorter than appearing to DM.
I went back to read the probable cause affidavit because I forgot this little teeny tiny little detail, and it did say that Dylan Mortensen said that he was at least 5'10".
Yeah, and I don't know how. I mean, the step. I can't even remember the house right now, but there was a step. I just think he was past that step.
I've always wondered because how can people tell that somebody's 5'10" or 5'7" or 5? I know if somebody's short or tall or in between, but I've always questioned these things where people can say, oh yeah, unless you're standing in front of one of those rulers that they have in the perp room in the police station, how can you? So I don't know.
And eyewitness testimony is subject to cross-examination, recall. Did she wear glasses? Did she need her glasses?
It was dark. It was the middle of the night. It was, between 3 and 4 or 4 and 5 or 2 and 3, depending on who you listen to. So I question this, but thank you for the comment. Appreciate it. And the last one we're going to look at today, she wears funny hat. What a funny name, but thank you. Thank you for the comment. I like the new judge. He is helping the case move forward. I think a lot of people think that.
I think that. I mean, I think he's being, some people might say, a jerk, but he's setting the tone. And like in California, those are the kind of judges that I'm used to, where you got to have your ducks in order, and you need to be able to pinpoint where you highlight portions of the testimony and page line and all of that. I mean, I even do that for mediation briefs. When I have a mediation brief and I want to highlight testimony, I do that. So, it just could be that they had so much work that they put it together and the timing, it's happened to me.
Yeah, I agree 100%. I don't mind a judge that's a little bit tough. I kind of expect it because I got out of law school and was working for a firm, and I was thrown right directly into trial work in Boston.
Me too.
I was just thrown right into it. I think my second or third trial, my mentor who actually hired me, and he's passed away recently, sadly, but he, at my second or third trial, then he came and watched and took copious notes about, suggestions of things. I still have those notes to this day. But my point is, when I was just out of law school and green out under the years, because you're not a trial attorney until after you've tried some cases and you've learned trial by fire. I've had some judges be pretty tough. But if they're tough to both sides, it's like, what do you expect? What do you expect? And the more you do it, the more comfortable you get. And if the judge is a tough guy, I don't mind it if he's being tough to both sides. But so we
haven't had a chance to see much of him. So we'll see if he's tough with the prosecution.
Yeah.
Because I have a feeling with all these discovery issues that Judge Hippler might have been better able to handle it than the prior judge, but who knows?
Well, he's sharp as a tack. I think that's true. I think he's sharp as a tack. He came out in the very first hearing saying, "Oh, I wish I could say that I was happy to be here, but let's not start with a mistruth." So he kind of set the tone that this isn't a party. This isn't
Right.
this isn't just the kumbaya moment. It's So anyhow, I don't know. Do you have any closing thoughts?
No, I'm just waiting to hear. I'm anxious to hear whether the Franks motion is going to get a hearing date.
Yeah.
And that's what we're waiting for. And the other thing was the motion by the prosecution to get an additional assistance from the Attorney General. And the defense objected to that.
Yeah.
So I don't know what's going to happen with that either. That's another ruling that I expect to hear from here.
We'll watch for that. We'll watch for that as we're taping this episode. It's late in the week, so that's when things happen. But anyhow, my closing thought is that there's a lot to come in the case. The new year will bring a lot of activity in this case, and we'll just have to see what's happening. The other closing thought I always have, I think the quality of our comments is really improving. I've said a million times, no name calling, no, disparagement, no using, nasty words to talk about. If you feel that strongly about somebody that you're going to call them whatever you call them, don't use that word. Tell me why you feel that way. And I've had to delete fewer and fewer. So I think people are actually listening to this. Now, Lainey has started a new thing. And if you've joined us in progress, Lainey is off this week. And I was so happy that Yolie could join us. Thank you, Yolie.
Mm-hmm.
Lainey started this new thing where she asks people if they have followed us or watched us through the whole episode. At first she said, leave us a blue dolphin, and they did. Then she said, leave us an apple, and they did. And then last week, a sunshine. So what should I tell them? What emoticon should I tell them to leave? A what?
A hot dog.
Is there one for a hot dog?
I don't know. I think.
All right. Well, leave a hot dog or a hamburger. Leave a hot dog or a hamburger if you've made it all this way. So thank you, Yolie. Thank you so much for filling in. I can't do this myself. I just can't.
Well, thank you for having me. Sorry about the technical problems. I'm in a different room, so.
No, you're fine. You're fine. I can't do this alone for a lot of reasons. One is that Lainey's a techie and she, things always go wrong. So knock on wood so far. Yes, I pushed the recording button. Yes, my computer was in the shop this week and it's working. So hopefully everything's copacetic and we'll drop this. And Yolie, again, thank you, folks. Have a good weekend.
Bye.
Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.